Good morning, and welcome to the first episode of our newest webinar series, Coffee with Casey. And happy Cinco de Mayo, by the way. I'm Casey Hicks, a shareholder of the Chicago office of Weltman Webinar Series, and also the managing attorney here. I'm looking forward to kicking off this series with everyone. I have my coffee ready. I hope you do too. Today I'm drinking Big Shoulders coffee, which is brewed right down the street from our office here in the Loop. Feel free to send your drink of choice in the chat. I love coffee. I'm always interested in new brews, so I hope to get some tips on coffee today. I'm going to go over some quick housekeeping items. As a reminder, this is an interactive session, so please feel free to submit any questions you have throughout the presentation through the question button in the control panel. I'm looking forward to having an open conversation with everyone about today's topic, collecting in the COVID-19 world. Also, this webinar is being recorded. At the conclusion of today's session, a link to the recording will be sent to all of the attendees, and there will also be a short survey on your screen at the conclusion of the event. Please take the time to take the survey and share your feedback. I would greatly appreciate hearing any opinions that you have about this webinar, or if you have any topics that you would like to hear about in our next episode. Finally, before we get started, I do have to share our legal notice for webinars. This seminar presentation will provide information concerning potential legal issues, concepts, factual situations, and information. This seminar and the material provided is not a substitute for legal advice from qualified counsel on any matter, including similar or exact factual scenarios that may be provided or proposed. This presentation is not created or designed to address the unique facts or circumstances that may arise in any specific instance, and you should not and are not authorized to rely on this content as a source of legal advice. I advise you to seek competent legal advice on these topics. This seminar or seminar material does not create any attorney-client relationship between you or the law firm of Weltman Webinar Series. All right, let's get to it. So a little bit about me, I wanted to share. I do know some of you that have signed up for this seminar today, but there are some of you that signed up that I don't know. I was born and raised in Lafayette, Indiana. I'm a huge Purdue Boilermaker fan. I love watching Purdue football and basketball, and I was extremely disappointed in our basketball's run in the tournament this year. I moved to Chicago for law school. I've been in the Chicagoland area ever since then, and I have been practicing for 16 years. I started with Weltman Webinar Series in 2014, and I've been here for 8 years now. I love to run. I spend a lot of my free time running, training for marathons or half marathons. I love books. I love suspense books, and I also am completely obsessed with Ozark and spent my weekend binging the remaining 7 episodes of the series. So if you've watched it, I'd love to chat with you about it. A little bit about Weltman, the Chicago office. We're located here in the Loop at Lake and LaSalle. We have 4 attorneys that practice out of the Chicago offices. We are one of 7 offices of Weltman, and the Weltman law firm itself has been around for well over 90 years. And a little bit about this series, since this is the first episode. I started this series kind of as a casual way to connect with clients, prospects, and really anyone in the industry to discuss the topics that we face in our practice here on a daily basis. We've had to go through a lot of changes since the COVID pandemic began in 2020. We still continue to see those changes and the way that it affects the way that we practice law, either by Zoom court hearings, Microsoft Team meetings, all the new technology that we either had to learn or become more familiar with to continue practicing law and to continue being a great advocate for our clients. What I'm really hoping to do with this series is to cultivate deeper connections between myself, the attorneys here in the Chicago office, and other guests that I might have from Weltman on this series, just so that we can all get together and talk about these issues that we're currently facing within our practice. I'm really supportive of knowledge sharing, and also I love to give back to my community in any way that I can. All right, so the topics that we're going to discuss today are court-ordered mediation or early resolution programs, post-judgment collections, more specifically bank citations, wage garnishments, and liens on real property. Because if you can't get someone to pay voluntarily once you get that judgment, I'm sure you all want to know the best way to collect on that judgment. And again, please feel free to send any questions through the chat feature through this series. I don't mind being interrupted with questions, so please feel free anytime you have one to just shoot it through the chat. All right, first thing we're going to talk about today is court-ordered mediation or early resolution programs. We've seen a lot of these programs pop up, especially a lot in Illinois with the pandemic. Illinois has chosen to use a lot of their CARES funds to develop these programs. A lot of counties have chosen to develop those programs for mortgage foreclosure cases. Those are the majority of the type of programs that we've seen. Within those programs, there's usually a scheduled mediation date that would be included on the summons that the borrower is served with when a mortgage foreclosure case is filed. Then the borrower can choose for themselves if they want to participate in that program or not. Cook County in Illinois is one of the outliers that has instituted a mandatory program for consumer debt cases. And consumer debt cases are when you're filing a breach of contract case for non-payment for a car loan, a credit card, a HELOC, any of those types of cases that would be consumer debt, and the damages you're seeking are under $50,000. All of those types of cases are going to be subject to what's called this early resolution program, or ERP. And how the ERP program works is once your lawsuit is filed and the consumer is served with a summons, you're given what's called a case management date. Now, this case management date is typically scheduled between 120 to 180 days after the filing of your complaint. So during that time, you complete service. My office will typically try to reach out to the consumer to come to some sort of settlement prior to the case management date. If that doesn't happen, we cannot move for judgment or trial or anything like that until after the case management date has occurred. If the consumer shows up at the case management date, they can choose to participate in the program. If the consumer chooses to participate, they would meet with the ERP case manager who's in attendance at the Zoom court hearing. The consumer would be transitioned over to a breakout room with the ERP case manager to kind of privately discuss their situation. The ERP case manager would then assign that consumer to a pro bono legal counsel, and then that pro bono legal counsel would typically contact our office to try to discuss a settlement. If we can settle the case with the ERP case manager, we will do that. If we cannot, the case would then move forward and be transitioned out of the ERP courtroom over to what we would call a trial courtroom. Once the consumer has had that opportunity to go through the ERP program, we are free to move the case forward with either a motion for default judgment, motion for summary judgment, or to set the case for trial. Unfortunately, if the case doesn't settle during the ERP program, it does kind of slow down our timelines to get our cases to judgment. So that's a little bit of a downside for the creditor side. If you are able to settle your case during the ERP program, of course, that's great. But if you're not, you're looking at kind of like a delayed trial date solely because the consumer has to go through this program first. All right. Once you get, a question came in. How often are these cases settled? Typically, what I'm seeing, we're probably seeing, I would estimate about a 30 to 40% settlement through the ERP program. That's just a rough estimate, so take that for what it is. But we do see a little bit of an increase. I think sometimes consumers are a little nervous when a law firm reaches out to them after they've been sued. We do see a lot of the consumers that show up at these ERP case management hearings are the consumers that are looking to settle their cases. So if we do have a consumer that shows up, pretty good chance that it's likely going to be settled. Another question, what is the SOL to file judgment in Illinois, and does this vary with fraud? I think this question is relating to statute of limitations. So there's different statute of limitations within Illinois depending on what type of documents you have. A credit card debt in Illinois is considered an oral contract, so that would be a 5-year statute of limitations. A written contract is typically 10 years statute of limitations. If it's a contract for the purchase of goods, your car loans, those have a different statute of limitations, and those are usually 4 years. The statute of limitations does not typically vary with a fraud account. There are other things that could delay the statute, bankruptcy or something to that nature. I hope that answers your question, and thank you so much for asking questions during this presentation. For judgments, once you have a judgment, if you cannot get your consumer to voluntarily pay, how are you going to collect? So there's a couple different ways that we have through the legal system that we can assist with collecting on a judgment. Those are bank citations, wage garnishments, or recording a lien on real estate or property that's owned by your consumer. And here at Weltman, we do have what we call a skip trace team, where we are able to skip trace consumers once we have a judgment. We can check to see if they're employed. We can check to see, we can run a search for bank accounts, and we can also check to see if they own any property. For bank citations, once you file a bank citation, the bank must be served, and they must, then they are required to file an answer with the court detailing if they are holding any property for your consumer. So if they have bank accounts, the bank account last 4 digits of that bank account and the amount that is in that bank account will be listed on this answer. In Illinois, the bank has, unfortunately, no specific deadline to file this answer. So sometimes we will have a court date for a bank citation where we're still waiting on the bank's answer. In Wisconsin, the bank's answer is due within 20 days. Your consumer or your judgment debtor does have a right to claim certain protections or exemptions. In Illinois, this is a $4,000 wild card exemption, and in Wisconsin, it's a $5,000 aggregate value of their accounts. In Illinois, the wild card exemption can only be claimed once throughout the entire case. And, oh, we have another question. In Illinois, can you file a bank citation more than once to the same bank? Great question. No, you cannot. In Illinois, you can only file bank citations against banks once within the life of a case. For example, if you file bank citation against Chase and there is accounts found and you're able to get that money turned over to you, you cannot then later file another citation against that same bank unless there's been a very, very specific change in circumstances, but those very limited. So one citation, one bank in Illinois. Other exemptions that are available, I just want to highlight, they are there on the screen, but Social Security disability funds cannot be attached. Any public assistance funds, unemployment, veterans benefits, pension or retirement benefits, things like that cannot be attached. Those will be exempt from turnover in any bank citation. Wage garnishment. All right, so in Illinois, for wage garnishments, the employer is served again, and they must file an answer. Again, no specific deadline in Illinois for these answers. A lot of times we will have to follow up sometimes with employers to make sure that they file their answers. A lot of times with smaller companies, they're not really aware of the requirements, and sometimes we have to educate them a little bit. In Illinois, a creditor can garnish the disposable income that's either 45 times the federal minimum wage or the Illinois hourly minimum wage, whichever's higher, or 15% of gross pay. And in Illinois, the garnishment is in effect until the debtor is no longer employed at that company or your judgment's paid in full. We did have another question come in about bank citations, and does the wildcard exemption apply to non-bankruptcy situations? Yes, it does. The wildcard exemption of $4,000 in Illinois can be claimed for any bank account at any time during the life of the case, but it can only be claimed that one time. Okay, Wisconsin. Again, wage garnishment in Wisconsin, the employer served, they must file an answer, and the answer must be filed within 20 days. The creditor can garnish the lesser of 20% disposable earnings, or the amount that the disposable earnings exceed 30 times the minimum wage. So it's a little bit different than Illinois. Wisconsin defines disposable earnings as funds that remain after deducting Social Security taxes, federal and state income taxes, and things like that. So that's your disposable earning amount. The consumer also has a chance to file an answer in Wisconsin, and the garnishment will only last for 13 weeks in Wisconsin, and then you have to refile it unless it's extended by agreement. We did have another question come in. Can a wage garnishment and a bank levy be effective simultaneously? Yes, they can. You can file both of those at the same time. There's not any limitations on that. All right, recording liens on real estate. Once you get your judgment, you can record a memorandum of judgment in the county where you believe your consumer owns property. Once that judgment is recorded, there is a lien that attaches to any property that's owned by the judgment debtor or consumer in that county. The lien will be in effect for 7 years from that date of judgment unless your judgment is revived. In Illinois, you have to revive your judgments within 7 years or they go dormant. But a judgment can be effective and executed on within 20 years. So you can revive a judgment a couple of times, typically in Illinois. We had another question come in. With the increase in at-home employees, are you able to help with wage garnishment files outside of Illinois and Wisconsin? We do have offices in multiple states here at Weltman, but we also have what's called a national forwarding network, where we do handle files with in conjunction with our network of local counsel for all of the states in the country. So if you do have files that you would want to refer over to Weltman outside of our typical footprint states of Illinois, Wisconsin, Ohio, Michigan, Pennsylvania, we would be happy to help you out with those. All right, docketing your judgment in Wisconsin. Each clerk of the circuit court in Wisconsin maintains what they call a judgment docket and a lien docket. And this serves as a record of all judgments that are entered and docketed in that county. So judgments are not automatically docketed, and there's typically a $5 fee that does have to be paid to the circuit clerk to docket your judgment. Once a properly docketed judgment is in effect, it's on that roster of judgments. Then you can go ahead and effectuate executions within that judgment. Once it's on there, it is good for 10 years in Wisconsin. A docketed judgment is a prerequisite, as I just stated, for any further collection efforts that you want to do in Wisconsin. We did have another question come through. When do you have to revive a judgment? So in Illinois, that would be 7 years. And then here for Wisconsin, you would need to redocket your judgment after that 10-year date. All right, please let me know if you have any other questions. It looks like one here just came through. If you are in the middle of service, can the statute of limitations expire? So once you file your lawsuit, as long as that lawsuit and that complaint is on file before the expiration of the statute of limitations, your lawsuit is good to go. You do not have to effectuate service because the statute of limitations is in relation to when your complaint is put on file. And I'm just checking to see if we have any other questions come through. I really, really appreciate all of you guys attending this morning, all of your questions. We had a lot of great questions come through. Please take the time to complete the survey at the end. I really would appreciate your feedback. And again, if you had any other topics that you're interested in. I'm planning, a few other episodes throughout the year. And the next one we're getting ready to prepare for is going to happen on Friday, June 3rd. And I'm going to have a special guest, one of my colleagues here, fellow attorney, Drew Walgreen. And really looking forward to that. I know he's looking forward to that too. So you'll get an email about registration for that next episode, again, Friday, June 3rd. And if you have any other questions, after we close out this webinar, you think you come up with something else, happy to answer them. My phone number is right there on the screen, as well as my email. And I look forward to seeing you at our next episode. Thank you so much for your time this morning.